All right, again, Kara was one of the victim's best friends, Shannon's best friends. So, Katie, I want to ask you this. Here's what I wonder. When you have a crime that happened 12 years ago, and this was one of her good friends, so she was probably in her early 20s as well, 12 years later, how well is she going to remember, in your opinion, the details about what happened that night?
Well, when something this tragic happens, it sears into your memory. I would think that she would remember it very well because it's such a huge impact, and obviously it's not something that happens so commonly. So I think that this would be something she would recount quite well.
All right, and Julie, how do you find her demeanor? Is it something that do you think the jury is going to find her credible and listen to all of her words and take that as the truth?
Yeah, and I keep in mind, you know, the prosecutor is building their case, and so what they start off with is those witnesses that knew the victims and can establish where they were prior to the incidents happening. I'm not so sure the jury really cares whether she was, you know, leaving at 4 or 3 when it comes to this case, because I don't think there's like a timeline that's going to impact whether or not Boyd was involved in this case.
All right, very sympathetic witness. Now, court has resumed. They finished their lunch break. We're going to go directly back to court now with the first witness following the lunch break. Xavier Jenkins currently testifying. We are live. It's resumed after the lunch break, and he is testifying that he saw the victim's forerunner, and the victim is Christopher Newsom's forerunner, at the house on Chipman Street. So let me start with you, Julie. How does that connect this crime to the defendant, or is this just a little piece of the puzzle?
It doesn't connect them to the defendant. And remember, they're not required to connect every single piece to the defendant. What they're required to do initially is set the picture for the jury so the jury understands every aspect and what each person did to participate in. Then, obviously, they need to establish that this defendant did, in fact, participate in this crime.
All right, so he sees the car there. Now, we already know that there was a carjacking because we have a plea in this case. We have other defendants, and I did want to clarify for the viewers, there was a 4th defendant in this case, co-defendant, who has also been convicted. She was not convicted of murder, but was convicted of many of the other crimes. Julie, thank you, pointed out there was a 4th co-defendant, so I didn't want to mislead in that regard. But Katie, let's talk about, in terms of this witness and what he saw. So it places the car at Chipman Street. What else in terms of the Chipman Street do you expect, or would you anticipate, in terms of the defendant actually being seen entering the house or not? It's my understanding we don't expect that there were any eyewitnesses that saw that.
Right, I agree. Either they're going to make some connective tissue between the defendant and that address, or this is just part of the menagerie of just information that we're going to have in order to set the stage and to understand exactly what happened.
All right, and there are so many crimes involved with the killing of these 2 individuals. As we mentioned, this defendant is actually facing 38 counts, so there's a lot of evidence that we anticipate will be presented. Xavier Jenkins being cross-examined. So here's what we know from his testimony. This is the prosecution's 3rd witness that they've called, and he has testified that he was a trash man and he was parked waiting on his trainer when he saw a few different things. One is the forerunner that belonged to one of the victims. The other that he's talked about is a white car with a red pinstripe on it. So let me turn to you, Julie, first. I think you may have been doing a little bit of research and have more information about what do you think of that second car that he's identified and any significance based on what you know?
Well, first of all, I think the detective did a really good job because he did a lineup with the car, and that's not usually the case. And so what he did is he wanted to test his ability to remember, and so he showed him various cars, and he ended up picking out the car. And I believe, and this is where I'm still investigating, I believe that car relates to the defendant, because for some reason, and I'm trying to find it, I believe somehow I think it's owned by one of the defendant's cousins. So that may help tie him in to potentially the murder of these 2 individuals.
I could tell you, I've been trying cases for a very long time and on the bench, and I have never heard of a car lineup before, to your point. I thought, what an interesting way to describe it, but that's what it was. So Katie, let me ask you, so the defense has just asked him about the fact that he has testified numerous times. I think he said 8 is what the defense attorney said, and he said, well, you know, over the last 12 years, yes, I've testified a lot. How much does that affect a witness's testimony and the veracity of what they're saying?
Well, one can take from that this has become over time rehearsed, practiced, and at some point maybe the truth gets whittled away as you wind up just reiterating a story that the prosecution wants you to tell. That would be the defense's perspective. In reality, the truth is the truth, and it may not actually affect the credibility, but I think it's a good point for the defense to argue, and kudos to him if he does.
And ladies, overall, I think these witnesses have been very well prepared in terms of understanding what they're going to be asked and what they need to remember. And that witness is done testifying. I want to discuss it again with my panel. Let's talk about first, because we did talk about this on a break, even though there was an unrelated reason that we were smiling and laughing. Certainly we understand and recognize the horrificness of this crime. Really atrocious, the facts around this case, whether it was this defendant or not, whether he's convicted or acquitted, I think we can all acknowledge. So around that, talk about, and Katie, I'm going to start with you, the attitude of this witness that he just got with the cross-examination. I noted that he was looking only at the attorney. He didn't look at the judge. He didn't look at the jurors, and he engaged with him. What do you make of that as a defense attorney? Is it good or bad for the defense?
I think it helps the defense because it shows that he might be biased towards the prosecution. He's engaged in this like fisticuffs with the defense attorney, and it shows that even though he shouldn't, he has some skin in the game. He feels married to his prior testimony that he did on behalf of the prosecution, so they're trying to show him to be that, not objective and aligned with the prosecution.
So let me ask you, Julie, I know as a great former prosecutor and now as a criminal defense attorney, here was something I noted he said. He insisted more than once in his answers that since 2007, when he filed the report about the Forerunner, that he has had absolutely no exposure to any media coverage about this set of facts or this particular crime.
Right, and we were talking about the fact that we find it a little unbelievable. Now, there are people that don't even have media, they don't have internet in their houses, and that's possible. But there is a feeling of lack of credibility with regards to that one thing, and it does, at the end of the day, allow a jury to say, if he's not going to be honest about that, then perhaps he's not being honest about everything. Let me just add one thing, though. He's been up there on multiple trials. And quite frankly, he's probably tired. And that is a factor that goes into perhaps his abrasiveness towards yet another defense attorney cross-examining him.
And that's a very valid point. And I suspect what he also means is he has made an effort to avoid all media coverage and social media and block people who talk about it. But certainly for all of us, that doesn't mean that we might not have heard it in the background without realizing or paying too much attention to it. We're going to take a break here on Law and Crime, and then we'll resume this trial live out of the state of Tennessee. Eric Boyd. You can see the judge is there talking to somebody. It looks like he's looking, I'm looking at my monitor, looking at something that they're showing him. So the defense is arguing or basically saying, listen, if this is going to be used, the transcripts from the prior trials against other co-defendants in order to impeach this witness, I think he's saying you may need to do it differently, or I want to make sure we're understanding the correct process so that this is done correctly. He also said he basically wanted the prosecution to kind of let him in on what her plan was or what she was doing. Julie, is it typical to stop in the middle of a trial to basically say, what are you doing, prosecution?
It's not. I'm surprised there weren't objections before the witness began to answer the question. So I almost feel like we're missing a piece, or we're not missing a piece, and the prosecution just decided to go in without asking the judge permission and just asking her about prior statements.
Oh, I think we're missing a piece too, because I'll tell you, I was listening, I was watching, and I didn't hear anyways the questions of, was it your car? Did you lend it to anybody? Did the questions that have to be asked first before you try to impeach. But let me ask you your opinion, Katie, on how this is proceeding.
Right. I mean, the only thing I can imagine is that the judge is going to review this to, number one, see if the statements are in fact inconsistent such that they can be used to impeach, or number two, to evaluate its indicia of trustworthiness, because you can't impeach on prior statements that are inherently untrustworthy.
All right. So let's go back to court to hear what the state's saying. So this is a hearing outside the presence of the jury. The defense is challenging her, I believe, saying, listen, we don't know whether or not she had been truthful, if she has the right to if the state has the right to use these statements to impeach. Do you agree with that? What's going on, Julie?
I'm a little confused. This is certainly not the way we do it in New York. One of the things I just noticed, though, is she's basically admitted to perjuring herself at the last trial, because first she said it wasn't true and she was just basing it on what she read, which would be that she swore and lied. And then the second thing she says is, well, I don't remember what I said. So to me, there's some elements of her perjuring herself.
All right, Katie, have you ever seen this in your experience?
No, and from this flash research that I've done, this could be under Tennessee's Rule of Evidence 80326, that where they're trying to offer prior inconsistent statement, not to impeach, not to show that the person's lying, but as substantive evidence. And here that requires a hearing outside the presence of a judge to determine whether there's an indicia of truthfulness or reliability. So that's why they're going through all this stuff. Well, did you testify truthfully the first time? Because if she does say, I was lying, then they can't use that as substantive evidence.
Right, so she has perjured herself. So interesting to note, I know that we had a comment about here with the panel that this is her cousin, keep in mind, this defendant, and the other co-defendants she testified against, and apparently the transcript said that it was her car, are not related. Julie Rendelman, thank you. I'm going to sign you off. I know you have to leave us. Katie Smith is staying with us. Come right back after this break.